this regard, the Saturdays and Sundays beginning next week and subsequently up to the time when there is need to file documents, the registry of the Supreme Court will be open. It will be a working day for the court from 9 to 5 o'clock. And we hope, and it is in your interest, that on each of those days and subsequently, when documents are supposed to be served, please maintain the presence of a representative. We must have a stamp of the law firm representing, or one of the law firms representing the petitioner on each of the respondents, so that when the document is served on you, you're able to stamp on the court copy and sign that you've received. I believe I'm clear on this. Is there any question? No? Are you seeking any clarification? Yes, Councillor Kiwanuka.
Yes, may it please your Lordship and honorable members of the Supreme Court, honorable justices of the Supreme Court. Everything is pretty much clear.
No, you have to tell these machines what your name is. It doesn't recognize you until you...
Most obliged. Yes. For the record, my Lord, my name is Chiriwa Chwanuka, counsel for the first respondent. My Lord, pretty much everything is clear, save for one issue on electronic evidence. We understand that the same will have to be filed with affidavits and served on the parties so that we can be able to challenge it either with counter evidence or challenge it legally. Because the dates were given for receiving electronic evidence which was outside the time for service of affidavits. But we just want to clarify that by the time they are presented for viewing, they would have been introduced properly using an affidavit so that we can be able to put in affidavits in response and or challenge them legally.
That's the law, no?
Yes, my Lord.
Yes.
Most obliged.
So you cannot bring an electronic evidence except by affidavit.
Most obliged.
By the time we reach that date, then we determine its reception and admissibility. Yes. Yes. Any
My Lord, I can only say it's axiomatic, and we shall follow the rules.
You follow the rules. Thank
yes.
you. Yes, my Lord.
I just wanted to inform Council Kirewa. That's why we have given you a night schedule for filing affidavits. Unlike in the previous petitions, where affidavits were. I'm saying that is why we gave a strict timeline for filing all affidavits. Unlike in the previous petitions, where affidavits were filed, sometimes throughout the hearing. Then the parties will not know each other's case. And then you have this trial by ambush going on in the petition. And I think that's what we want to discourage. So when you bring your electronic evidence, we must introduce them by way of affidavits, so that on the 24th, we shall now be viewing them. But they will have already been shared with each other. Thank you.
Let me emphasize this. Thank you, my Lord. Let me emphasize. You see, we've lost 10 days. And there is no way we can cover the 10 days. So the strict timeline I have given for filing affidavit evidence, you'll be lucky if you will be allowed to file an affidavit evidence outside of that timeline. So you really got to go and do work. Because there's a great danger. It will lead to serious ramification if we expand the latitude that you can file an affidavit whenever you want. So the timeline I've given for these actions is really strict. It is also strict on the court. The court must, all those volumes, the court must determine within a space of 10 days. So similarly, you must do your work within the timeline court has given. Thank you.
Can I emphasize? Can I emphasize?
Yes.
I'll go first?
No.
Okay. I just want to emphasize that the registry staff have been instructed very strictly to reject any document that is brought outside the timelines we've given you. We don't want to find documents on our files in the morning of the hearing that has been filed outside the timeline given. So if you are late, forget. They will not receive your document, and you'll have only yourself to blame. Okay? Thank you.
Thank you, my Lord CJ. I just wanted also to emphasize that if there is any correspondence, Council Lubega, you mentioned that you had written to the second respondent. I'm not aware if that correspondence has been put on the court record or copied in on the court record. So this, again, to expedite or to assist the court in reviewing, who has taken which initiative and where there are any difficulties, like the Chief Justice has said, if the parties are corresponding to each other, they must copy in to the court so that court can be updated at all time where you are.
My Lord, we undertake to do that going forward.
Okay.
My Lord,
just let me follow up on that. I really appeal to counsel, especially counsel on both sides. This is about justice. This is about determining whether the grievance before this court has got merit or not. It's not about winning. It is only when you seek to win that you can say, I'm going to deny this document, I'm going to be this. It is. And let me also say, it's not about the petitioner. The question before court is about whether and how we can have an election which everybody is satisfied by. So please, the moment council pursues a winning attitude, by all means, by all means, then we deviate from the purpose for which we are here. And elections are not about the candidates. It's about you and me. It's about our country. So I expect total cooperation. I expect decorum. I expect that we pursue. We are going to investigate. We are going to inquire into the grievance which has been presented before court. And because of this, yes, Council.
My Lord, my name is Joseph Matsiko for the second respondent.
Yes.
My Lords, with your permission, I'd just like to clarify for the record.
Yes. Is the mic on?
And to clear the record, my Lords, that counsel for the petitioner has not served on us any letter requesting for any documents. We have not received any such letter. So I just wanted to clarify that impression. So it's not true that we were served with any letter requesting for any documents, my Lords.
Thank you. Whatever the position is, either two, subsequent to this sitting of court today, we expect total cooperation. We expect that learned counsel, whose responsibility is primarily to this court and then secondly to their clients, will do everything in their power to see that justice is done. Learned Attorney General, you're head of bar, you know this. It includes availing your opponent in courts, authorities which they may not have, which would help their case, but you have it. That's really what it means. If Mr. Kiwanuka has some authority which Council Lubega has never heard of, and it improves on Council Lubega's case, the professionality of legal practice says you avail it to the other side. And that's how we should proceed. Yes, it's what makes the legal profession beautiful. It is why you're called learned. You're not just educated, but learned. So it comes with responsibility. Then finally, and this to both parties, to all the parties, the four parties, to the media, there are rules about court cases. They are age-old, and they are there for a purpose. The petitioner has chosen to come to court. He has not chosen to go and present his case in a marketplace. Leave the courts to do their work. And this begins from council. I have seen in the print media, I have seen on TV, some people appearing, we shall defeat this case. This is the forum where you can defeat the case. This is the forum where you can succeed to overturn the outcome of the presidential elections that was held on the 14th and declared on the 16th. Nowhere else. We will not take kindly to anyone, more so council, or the parties who have chosen to come to court, who have been dragged to court, now thinking that having had their day in court, they must also have another day elsewhere. We are here because you believe in the rule of law, which is a commendable thing. We are here because you believe left to do their work. This court can do something. Leave the courts of law to sit down and render justice, as is their mandate to do. Let us not misuse social media. If we choose to go to social media to inform, let us give factual information on what transpired in court. That is permissible. Not this disparaging and mud throwing and so on and so forth. For those of you who are old enough, you should know the alternative to a court of law. It is until you're put with a situation where you have a military tribunal. We have seen this before, handling purely civic matters like this. Then you'll cry for a court of law. Some of us are old enough, we saw this happening, where kangaroo justice was meted out. We saw it in this country. So my appeal to those who are old enough like me is to remind them to recall, and for those of you who are unfortunately not as old as I am, to know that the court of justice, the court of law, it may not be perfect, but you don't want the alternative to the court of law. So whatever you do, let us strengthen the courts of law to do their work. And this does not apply to the presidential elections petition only. There are other petitions which are coming parliamentary and for local government. Let us act with responsibility. This is our country. I do not own it more than you do. Nor do you own it more than I do. We own it together. We can destroy it together, or we can lift it up together. And posterity will judge us either in commendation or very harshly, depending on how we handle the opportunity that is present before us.
With information, I think, again, to set the record straight, I did not say that any communication with respect to what I said has been shared with Council for the second respondent. We have been corresponding with the Electoral Commission.
No, that's okay, that's okay. Yes. London Council Lubega, for me, my point is, from now, yes, whatever has transpired, you know, we can spend the whole day saying you did, you didn't do, but I am saying from now, I expect, I do not want Learned Council, whose responsibility is to me primarily, then because of that, they have a responsibility to the petitioner or to the respondents to look at one another as if they are opponents. They are not. They only believe that their client has a case, the other person says it is their client who has a case, and you have to present that before us. So I expect that the Attorney General will give you maximum cooperation, counsel for the first respondent, the second respondent, they will all give you maximum cooperation. And similarly, they may want some information from you. We expect it is, yes, it's not a one-way traffic. There's need for reciprocation. What you need from them, if they need something from you, I expect total cooperation. And that's how it should be. Thank you. So, unless something comes up by way of application, you've understood the timeline and when we will converge again here. Please follow the timeline given by court. Then we can all do this together and come to a determination for the good of our country. Thank you so much.
Thank you very much, my Lord, the Chief Justice. This is just to say that on behalf of the respondents, we thank you for the guidance that you have given us. The timelines are all crystal clear. And as far as the respondents are concerned, we intend to abide by everything. We thank you very much.
Okay.
My Lord, I think the Attorney General has abdicated on his statutory responsibility to represent the entire bar.
Yes.
But for the petitioner...
I was about to say that. That in his concluding remark, he should have spoken for,
yes,
for the bar, yes.
We thought he would not discriminate against us, but we take it with grace, my Lord.
Court takes it that he misspoke.
Oh, sure.
Yes.
I want to assume, and my Lord, for the record, that he was thanking you on behalf of the entire bar. And I think it is fortunate that some of us are not as old as yourself, my Lord, because we have somebody to follow from.
Okay.
Yes, we do not undertake or intend to advise on the alternative to this court. Mm-hmm. We are guided by the perennial conduct of court that we must always come here as the last person.
Yeah.
And it is our responsibility that we shall be here.
Thank you.
We do not intend to see that tribunal you have talked about. We have seen a semblance of it in much India, but we think we will get over it. Thank you.
I believe we will not see a military tribunal again. This is my belief. But all that I'm saying is, whatever deficiency the court of law may have, it is an institution. You don't want to go back. We have seen the alternative to a court of law. So in whatever we do, because we love our country, we may differ. Even on points of law, we may differ. But it is the duty of counsel, it is the duty of every Ugandan to strengthen the court of justice and ensure that it properly contributes to the stability and economic development of this country. There is no alternative. Thank you. Yes.